I think what I'd like to do today, start with picking up on some of the things that you've said and just feeding it back into things we've touched on, but not really gone. Law and justice seems to be a really interesting thing, especially when you do the anthropological comparative thing, because you've got your individualism, you've got your atomization of everything, you've got laws and things like this, and so it'd be interesting to see how the English legal system and notions of justice compare with this very different approach to how you organize society over in China or Japan. And I'm kind of asking, I suppose it's the same, it's an extension of the Needham question, who asked it about how is science possible? How is any sense of law and justice and stability, in a society that has constant flux, how is this possible to have a kind of legal system like our own? Or is it not possible? And is there actually a similar sort of issues around what is the legal system going to look like in China, and what are the possibilities there compared to what we've got, say, in the Anglosphere?
Thank you. As I usually do, I'll give a little back history of how I got interested in the subject. It's a curious fact that although I think law and justice are the most important feature of the Anglosphere, if you look at, as I've done before, at what distinguishes a civilization, so India, China, religion, America, to a certain extent, economics, and so on, the English, if you had to pick one thing that makes them really different, it's the legal system. But because it's so significant, the core, as it were, we were not taught about it. I mean, if I look back through all my essays at school, for example, there was one essay on Anglo-Saxons and medieval law. That was it. When I went to Oxford to study history for 3 years, there was an essay on Angevin law, which was very important, and maybe something else. But in the whole of 3 years of studying English history and European history, we hardly touched on law. And if you ask most people now, what do you know about the law, the English law, legal system? School children or university students or intelligent people, they know hardly anything. Now, this is very strange since it's so important. And perhaps I would have gone on with my ignorance of the subject and disinterest if I hadn't chosen for my DPhil the subject of witchcraft, because immediately I started looking at witchcraft prosecutions in England, I realized that law was a fundamental feature of this, the way in which witches, the law that made witchcraft a crime, and then the way in which they were tried, which was very different from that in the continent and Scotland, because the English didn't use torture. And also you had a jury system and so on. So I had to learn, and it was quite a learning curve for the first year or two of my DPhil, how the English legal system worked. And the other reason I had to do that was that as soon as I got into historical research on documents in England, I became aware that almost all of them were produced by legal authorities. About 90% of our historical materials in England are the product of law. The great bulk, of course, are manorial records, and these are manor court rolls. They're courts. But the huge central criminal and civil cases in the Public Record Office and elsewhere were generated by courts. And if you don't understand how, for example, the assizes work or the Court of Chancery or whatever, you're not going to really be able to do a good social history of England, which is what I was attempting to do. So by the time I'd finished my DPhil, I was deeply interested in law. And it proceeded from then on. I came to learn that some of our greatest historians, like F.W. Maitland, Sir Henry Maine, and others, were lawyers by training and interest. And so law was the key. Then when I went to Nepal, I went to a society where there was no law. I mean, the police were a distant presence in a remote town. In the village, all they did, which is what they do in almost all civilizations before modernity, was have a very informal system of settling disputes, whereby if you had a dispute, you would summon a few of the senior males in the village, and they would sit and listen, and they would say, well, have you thought of this, and this isn't right, and so on and so on. So it was settled by word of mouth, by customs and informal methods. And that's what you would find throughout Africa and South America and so on, traditionally through tribal societies. They don't have books of law or courts of any kind. So I came to a society with basically no law with a capital L, though there were lots of laws with a small L. And then when I came to Cambridge, because I was already interested in it, people said, well, Alan, I think you should lecture on law and so on. There was one other colleague who was interested in it. But so for some years, I gave lectures on comparative law in anthropology. And I began to read the large literature in anthropology and so on. And I came to see that the legal systems of the world are really divided in two, that is, leaving on one side the tribal customary systems. There is the English system, and there's the rest. The rest includes the continent, and it includes Japan and China. And the distinctive feature of the rest is that law is the enemy of the people. It is a tool of government. It is a way of keeping people in control, and it can be, and preferably is, as harsh and punitive as possible. That's why Foucault's famous book, Discipline and Punish, starts with a horrible account of torture. So for most people in most civilizations over the last 2,000 or 3,000 years, they have kept away from the law as much as possible, settle things locally, because once you get lawyers and others involved, you're in real trouble. And that's because basically in those kinds of societies, and it applies to China as much as it does to, say, traditional France, you have the state here on one side, and you have the individual here, and the state directs all its power on the individual. The individual has hardly any protection against the law. I'm talking about criminal law here.
And the criminal law thing that's one of the big things you notice, isn't it? That these laws systems, when they do have the legal system, it's mainly criminal law, which is not the same when you look at the Anglosphere.
Absolutely. Well, that could be another subject we discuss, because
right, okay.
Something like only 10% of English law is concerned with criminal law. It's terribly important and distinctive, but in China, there is basically nothing else. When I looked at Chinese law to see what the civil law system was, where were the lawyers? Where were the solicitors? Where was the books which are huge in England, of civil law, citizens using the legal system to prosecute each other? There's nothing. So this is a distinctive and huge feature, because in England, the law is something which individual citizens can use to uphold their rights against each other, particularly property rights, but many others. In most civilizations, you can't do that. There's no civil law, hardly any. And as a result, the only way in which you can protect your rights is through force. In other words, your family and kin and friends and the mafia and so on and so on. So the fact that we have a very, very powerful civil law in England is another enormously different and important